Okay, welcome everyone. Thank you so much for joining us today. Today's webinar, hosted by Equip for Equality, is on the Americans with Disabilities Act and best practices when applying for jobs as a person with a disability. My name is Hannah Walsh. I'm an attorney at Equip for Equality. I am just here to facilitate this meeting, so I will be, if you have any issues during this, please message me directly. Please put all your questions and comments either in the chat or the Q&A. We're going to hold those to the end, but I'm going to be keeping an eye on that to make sure everyone's questions get answered at the end. At this point, I'm going to turn it over to my lovely and brilliant colleagues, Sarah Huttenlocher and Megan Sorey, and I will share the PowerPoint now. Okay, I think that worked. Okay, goodbye.
Thanks so much, Hannah. Good afternoon, everyone, and happy Friday to everyone. I think before we begin our substantive presentation, Sarah and I just wanted to briefly introduce ourselves. So my name is Megan Sorey, and I'm a staff attorney at Equip for Equality. I have been with Equip for Equality for a little over 8 years now and have had a lot of great experiences working on various substantive areas of the law. And as of July of 2022, I transitioned into a new role here at Equip for Equality. You'll hear a little bit more about this new program. Sarah and I are both advocates on the Client Assistance Program advocacy team. So in addition to being staff attorneys, I am working more with a focus on employment and vocational services, and trying to really help folks with disabilities who want to work do so, and helping to remove the barriers to employment. So really excited to be in that new role and excited to speak with you this afternoon. So Sarah, would you like to introduce yourself?
Yes, hi, I'm Sarah Huttenlocher. I'm a staff attorney with Equip for Equality. I've been at EFE for about 1.5 years now. In my first year, I focused mainly on assisting with our employment rights helpline. And then like Megan, in July of 2022, I transitioned to our new CAP advocacy team. And I've been really enjoying getting to start doing CAP work.
Great. So this is Megan once again, and I am going to start us off. So if Hannah could be so kind as to advance the next slide. Thank you. So first, we wanted to just provide an overview of Equip for Equality in case some folks who are participating in the webinar today aren't as familiar with our organization. So Equip for Equality, or EFE as we call ourselves, is what's known as the Protection and Advocacy System, or the P&A organization for people with disabilities in Illinois. And the neat thing is that every single state and US territory has an organization like Equip for Equality, working with people with disabilities. And our mission here is to advance the human and civil rights of people with disabilities in Illinois. And we do that by providing free legal services to people with disabilities about issues that are related to their disability. And although we have 4 main offices throughout the state, we serve folks throughout the entire state of Illinois. So although I live and work in Chicago, I have clients throughout the entire state of Illinois. And we're organized into kind of 3 main legal teams or departments. So the first of which is the civil rights team. And Hannah, Sarah, and I are all attorneys on the civil rights team. We also have a special education clinic which works with students with disabilities and their families to make sure that they're receiving the necessary supports and services in the school system. And last but not least, we have our independent monitoring unit, which conducts abuse and neglect investigations and is able to go inside facilities where people with disabilities work and live. Next slide, please. And we wanted to just start by giving you an overview, a roadmap of kind of what we hope to cover during the session. So we're really going to talk a lot about what the Americans with Disabilities Act is, the ADA. The title of this presentation is geared towards best practices for job seekers and people with disabilities in the employment setting. So we want to talk all about the ADA and who is protected by the ADA. Specifically, we're going to look at the rights of job applicants and employees with disabilities in the ADA. And we're going to cover some common questions about disability disclosure and disability inquiries in general. We're also going to talk about reasonable accommodations and employees' rights to have reasonable accommodations when applying for jobs and in the job setting. We're also going to talk about some really helpful resources for job seekers and employees with disabilities. Specifically, we're going to talk about some great vocational services provided through the Division of Rehabilitation Services. And also, we're going to share some more information about the Client Assistance Program and the services and supports that we can provide to help job seekers and employees through that program. And we're also going to share some resources about some other programs here at Equip for Equality that may be beneficial to you or folks within your network. Next slide, please. So we wanted to start out by just giving an overview of some really important disability discrimination laws. And so there are disability laws that exist on the federal level, as well as laws that are at the state or local levels. So when we're talking about the federal laws, so those are laws that applies to all different states, right? Not just Illinois. The first of which being the Rehabilitation Act. And that was enacted in 1973. And that prohibits discrimination by entities who receive federal financial assistance. We also have the Americans with Disabilities Act, that great act that was passed by Congress in 1990. And so as we'll see, the ADA really applies to all facets of life, right? Because the goal of the ADA is to prohibit discrimination and make sure that people with disabilities have equality of opportunity and full participation and inclusion and independence and economic self-sufficiency. So as you can see, that really encompasses all aspects of life. And in addition to these federal laws, we also have the Illinois Human Rights Act here in Illinois, which also prohibits discrimination against people with disabilities. And here in the Chicago area and Cook County, we have the Cook County Human Rights Ordinance, as well as the Chicago Human Rights Ordinance. So all of those federal, state, and local laws are ways that people can enforce their rights and prohibit discrimination. Next slide, please. So as I mentioned, and as you can hear about in the purpose of the ADA, it really applies to every aspect of life. And so the ADA is organized into 5 sections or titles. So Title I is really going to be the focus of our discussion today, because we're talking all about employment. So that'll be, we're talking about Title I of the ADA whenever we're talking about employment protections. But Title II of the ADA applies to state and local government entities. We call them like public entities, and it also applies in the realm of public transportation. Title III applies to places of public accommodation. So when you hear about commercial facilities or how the ADA applies to private businesses, that's where you're looking, Title III protections. Title IV applies to telecommunications. And Title V is kind of a hodgepodge. A lot is housed within there. So it has some retaliation provisions, some technical assistance, and some other miscellaneous provisions. Next slide, please. So before we jump into a discussion about Title I of the ADA, it's really critical that we understand who is protected under the ADA. We have this great law here. So individuals with disabilities, as covered under the ADA, it kind of lumps into different categories of ways that you can be a covered person with a disability. Someone can be an individual with a disability who has a physical or mental impairment that causes a substantial limitation in a major life activity. So that's one way to be considered a person with a disability under the ADA. You can also be covered if you have a record of having such an impairment. And lastly, you can be covered if you are regarded as or perceived as having an impairment. Now, there are some provisions and protections for individuals who are associated with people with disabilities as well. And as we'll see in the next slide, so the ADA was passed in 1990. And in 2008, so 18 years later, we have the ADA Amendments Act, and that really expanded the definition of qualifying disabilities. So in the next slide, we'll see, this is a slide, and it's not intended to be the list of every single type of disability under the sun that could be covered under the ADA. But it's just to give you an idea of the expansion of the definition of disability and how a disability can be a physical condition, it could be a cognitive limitation, or it could be a psychiatric or mental illness. So I'll turn it over to Sarah to really dive into our Title I discussion today.
Yeah, so next we're going to talk a little bit more about employment rights specifically. And as Megan mentioned, those employment rights are all under Title I of the ADA. And Hannah, you can go on the next slide. And so first we're going to talk a little bit about what employers are covered. So what employers does the ADA apply to? And so Title I applies to private employers with 15 or more employees, all state and local government employers, employment agencies, and labor organizations. And so as you'll notice, private employers, the ADA only applies to private employers with 15 or more employees, but the Illinois Human Rights Act, which has similar provisions and similar employment protections, applies to all employers in Illinois. So even if an employer has too few employees to be covered under Title I, it would still be covered under the Illinois Human Rights Act. Next slide. And so next we're going to talk a little bit about who is protected under Title I of the ADA. And so the ADA prohibits employment discrimination against qualified employees and applicants who have a disability. And so what qualified means in this context is that an individual is able to meet the job's requirements in terms of education, experience, license, certifications, and that the individual can perform the essential functions of the job or the essential job duties with or without reasonable accommodations. So even if somebody requires a reasonable accommodation to perform the job, they are still qualified so long as with that accommodation, they can perform the essential duties of that job. Next slide. And so that brings us to the question of how do we determine what is an essential job function? And so there are a lot of different factors that can be considered when determining what the essential function of a job is. And some of these factors include an employer's judgment, what's written in the job description. So if a job description very clearly lists certain functions, those will, that might weigh into considering those essential functions. The amount of time that somebody who performs the job spends performing a particular function, the consequences if somebody isn't performing a certain function. So how does that impact their ability to get the work that they need to get done? If there's a collective bargaining agreement, the terms of that can factor in, and also just the experiences of others who have had or currently have the same or similar positions. So what have other people found to be the essential functions of the job? And no single factor is determinative, but these are all just things that are considered when deciding what is an essential function of a job. And so if somebody is found to be a qualified applicant or employee and they can perform the essential functions with or without accommodations, what protections does the ADA offer to those employees? And so Title I prohibits discrimination in all different aspects of employment. This includes, things like job application procedures and failure to hire. Somebody can't refuse to hire a qualified applicant solely because that applicant has a disability. Similarly, an employee can't be fired solely because they have a disability if they're a qualified employee. there's no discrimination in benefits and compensation. Somebody can't be paid less because of their disability. They can't be denied training opportunities or advancement and promotion opportunities. And they can't be discriminated against in any other terms, conditions, or privileges of employment. And then two provisions that are somewhat unique to Title I of the ADA when it comes to types of discrimination listed is that the ADA prohibits certain medical exams and making certain disability-related inquiries. And then also, discrimination under Title I is defined to include a refusal to provide an employee with a reasonable accommodation. And we're going to talk more about those two things right now. And I'm handing it back over to Megan to talk about disclosing disability.
Great, thank you, Sarah. So disability disclosure is a big topic, and certainly something that a lot of job seekers and current employees contact Equip for Equality wanting our advice about. So we thought it would be really helpful to focus on this topic here today. So the first question that we often hear from folks is, are applicants with disabilities required to disclose their disability to prospective employers? And that's definitely a really valid question and something that a lot of job seekers are really wondering about. So in short, a person who is applying for a job is not required to affirmatively disclose their disability on an employment application or during a job interview, unless they need a reasonable accommodation for the application or interview process. Similarly, if someone thinks that they will need an accommodation, not during the application process, but maybe once they're actually on the job and in that role, there's no need for them to request an accommodation upfront and disclose that information during the application phase. They can wait until they're on the job and need that accommodation. The next question that we often get is, are folks required to disclose their disabilities after they are hired? Again, this is a really, really good question. And the answer, just like the mandatory disclosure question about during the application phase, is no, not unless they need a reasonable accommodation to perform the job. So a lot of folks with disabilities have no need for accommodations on the job, and they're by no means required to tell their employer, hey, heads up, I have this disability. That is absolutely not something that you need to worry about. Next slide, please. And a more difficult question is, should applicants with disabilities disclose their disability to prospective employers? Unlike the previous question that was a little bit more black and white about what the rule is and when you would need to disclose, this question is a bit trickier because it's really a personal decision and an individual decision about whether someone feels comfortable disclosing their disability. Now, of course, that permissive disclosure is not the case if someone needs a reasonable accommodation. So there you do have to disclose, but otherwise it's really an individual and personal decision. Next slide, please. So we've talked a little bit about when an employee or a job applicant needs to disclose a disability, but we should also look into, can an employer ever ask somebody to disclose a disability? So we're talking about what Sarah mentioned briefly, these disability inquiries and medical exams on the part of the employer. So as we'll see in the slides to come, there's some limited circumstances where an employer may ask some disability questions or require some medical exams. But we'll see that what can be asked and what can be required really varies depending on what stage of the employment process that an employee is in. So we'll go to the next slide to start talking about this more deeply. So the first phase of the employment process, because remember, Sarah shared that the ADA applies to all stages and all aspects of the employment process. So we're dealing with the first phase. So this is pre-employment. So it's the application phase, the job interview, all of that, the early stage. And so in this phase, employers cannot request any disability-related information or require medical exams. And also a step further, employers cannot ask any questions that may elicit information about someone's disability. So an employer might have on a question on an application of, describe any medications that you may be taking or something to that effect. And so if an employee were to write down, that they were taking a particular psychotropic medication for a mental illness, or if they were taking an anti-seizure medication for epilepsy, that question about medications is impermissible because it elicits information about that person's disability. Now, there can be some exceptions. Some employers have voluntary questions where an applicant may be permitted to voluntarily disclose for affirmative action purposes. So so many employers really have an interest in hiring people with disabilities. So those voluntary questions may be permitted, as well as some questions about disability may be permitted at this early stage if an employer has a reason to believe that an employee may need an accommodation for a known or visible disability. So during this stage, we've talked about what employers cannot do. So it's important to share that employers can ask questions during an interview and an application to assess a candidate's ability to perform the essential functions of the job, right? And they can also ask questions specifically for an applicant to describe or demonstrate how they would perform those essential functions with or without accommodations. Next slide, please. So we're moving away from that pre-employment phase, and we're going into the next phase of employment, which is after the applicant has received a conditional job offer. So employers may be able to ask disability questions and require medical exams, but only if this is done across the board for all applicants and that the applicant with the disability is not being singled out in any way. Now, an employer cannot withdraw that job offer after asking those questions and requiring that medical exam unless the individual with the disability can't perform the essential functions of the job and there are no accommodations that would enable the employee to perform the essential functions. Next slide. And so we're moving to the last phase. So we've gone from when employees are interviewing, when they've gotten the job offer. Now we're dealing with current employees who are on the job. So the only situations in which employers can seek disability-related information is when it is job-related and when it's consistent with business necessity. So what does that mean? So it means that an employer has to have a reasonable basis to believe that an employee who's on the job is unqualified to do the job, that they need a reasonable accommodation, or that they pose a direct threat to the health or safety of others. So I think we've seen that the ADA and Title I really protects the types of disability inquiries and medical information that an employer can have at all stages of the employment process. Next slide, please. So just briefly to reiterate something that we've shared before of when someone might be required to disclose. So a job applicant or current employee may be required to disclose their disability in the context of asking for reasonable accommodations, whether that's during the job application, the interview, or actually on the job. So that's the situation when disclosure is required on the part of the employee. So the next slide, I'm going to turn it over to Sarah. We've talked all about asking for reasonable accommodations, and Sarah's really going to show what that process looks like and what the law requires.
Yeah, and so like we mentioned earlier, the ADA defines discrimination to include failure to provide reasonable accommodations for known limitations caused by a disability. And so what this means in practice is that employers have an obligation to accommodate employees and applicants with known disabilities. And a reasonable accommodation is defined by Title I as modifications or adjustments to the work environment or to the manner or circumstances under which the position is customarily performed that enable a qualified individual to perform the essential functions of that position or to enjoy equal benefits and privileges of employment. And reasonable accommodations tend to fall into three broad categories. There's accommodations for job applicants, which can be, modifications to the interview process or to the application process, basically accommodations that help somebody to successfully apply for a job. There are also accommodations that allow you to successfully perform the job. And so these are those accommodations that we're talking about when we say accommodations that enable somebody to perform the essential functions of the job. And then there are also accommodations that help ensure equal enjoyment of the benefits and privileges of employment. And so what this means is essentially, making sure that employees with disabilities have equal access to the same opportunities and benefits as other employees. So if an employer is going to, for example, send everyone to a conference or a seminar, they need to make sure that an employee with a disability needs an accommodation to attend that seminar, then the employer has an obligation to provide that. Next slide. And so what are some examples of reasonable accommodations? Reasonable accommodations are very broad, but they can include things like a sign language interpreter for somebody who's deaf. Extended time to take a pre-employment test is an example of an accommodation for a job applicant. Allowing break periods, permitting a job coach if somebody needs some assistance when they're settling in, instructions on how to perform the job provided in writing rather than verbally, or vice versa. So if you need a modification to the way that you're trained for the job, extended meal breaks or breaks to take medications if somebody needs to treat a medical condition, time off work to attend medical appointments, being allowed to park in a reserved space, modifications to make sure a building's accessible. These are all different examples of things that can be considered reasonable accommodations. And so this is a few facts about accommodations and about that kind of address some myths. I mean, there are a lot of employers who believe that accommodations are always very expensive or difficult to provide, or they might be nervous when they're asked to provide an accommodation. But the Job Accommodation Network, which we'll talk a little bit more about later, found in 2017 that 59% of accommodations actually cost nothing. There's something that does not require any extra money for an employer to provide it. 36% only have a one-time cost. Only 4% have an ongoing annual cost. And typical one-time expenditure is $500 or less. So these accommodations are a lot less expensive and a lot more easy to provide than a lot of employers believe. And it's really important to kind of break down those myths so that employers are more open when they get these requests and to fulfilling their obligations under the ADA. Next slide. And so next we're going to talk about how do you request a reasonable accommodation if you need one. So requests don't need to be in writing, but our advice generally is that it is a good idea to put your request for an accommodation in writing so that you have a record that you made that request. One other thing to note is that there are no magic words that need to be used. You don't need to say, I'm requesting a reasonable accommodation under Title I of the ADA. If you do say that, that can be helpful. It can be good to be very clear up front. But also, so long as an employee indicates to their employer that they need some kind of accommodation or assistance due to a medical condition that is causing some kind of issue for them performing the job, that alone is enough to trigger what is known as the interactive process, which we'll talk about next. And an employer should respond to that if they get that information and should start engaging with the employee to figure out how they might be able to accommodate them. If you are trying to make an accommodation request, you might want to talk with your supervisor or with the human resources department. Some employers have a very clear path that you take and clear people you contact to request accommodations. Other employers, it's a little bit less clear, and you might want to just talk with a supervisor you're comfortable with. Another thing to note is that a person can request an accommodation on the behalf of an employer, an applicant. And so, if you need assistance requesting accommodations, somebody else can request that accommodation on your behalf. And best practices for making a request is that your request should describe what your disability is, why you need an accommodation, and also if you know what sort of accommodation you need, it can be a good idea to suggest that accommodation, and maybe also a few alternatives if there are a few different things that will work. And if you don't know exactly what you need, you can also just explain that you need an accommodation and what you need it for. and, and then say that you'd like to initiate a conversation about it. And next slide. So here we've got an example of the type of accommodation request that somebody who is applying for a job might make. In this one, it says, dear, and here you might put, you might address this to the hiring manager, whoever you're talking with about your application, and say, I am deaf and will need an American Sign Language interpreter at my interview for this position so that I can communicate with the interviewer. I am asking for an ASL interpreter as a reasonable accommodation under the ADA. Next slide. And so, as I mentioned earlier, after somebody makes an accommodation request, the next step is for the employer and the employee to engage in an interactive process to determine what accommodations can be provided. And the interactive process is essentially a dialogue between the employer and the employee where they work together to find an effective and reasonable accommodation. And so ideally, they will discuss the employer applicant's limitations, their current work issue, and together they'll explore possible ideas and accommodations that might help. And ideally, consideration should be given to the employee's preferred accommodation because the employee generally is going to know best what will work for them. During this process, the parties can also exchange reasonable information, which means that they can, and we'll go into this a little bit more later, but employers can request documentation or more support for the request. And they should also consult with others as appropriate or as necessary, which can include doctors, computer experts, vocational rehabilitation experts, other parties who might be able to help figure out the best plan to accommodate somebody. Next slide. And so, as I mentioned, employers can request medical documentation after an employee requests an accommodation. So if the employee's disability or their need for the accommodation is not obvious, then an employer can say, oh, can you get me a doctor's note? Or, can I talk with your doctor to figure out more? The employer cannot request, somebody's entire medical history or anything like that. It has to be, the request has to be relatively limited to what the employer needs to determine the necessity of the accommodation, but they can request medical support. Unless the employer already has sufficient information. So if the employer is already aware of the employee's disability or it's a visible disability and the employer knows how it impacts the person with a disability, then the employer likely does not need a bunch of additional medical documentation because they can already see that there is a need for this accommodation. And so one other thing to note, and we touched on this a little bit earlier when we said that consideration should be given to an employee's preferred accommodation, even though that is ideally the best practice. The general rule under the ADA is that employers do have an obligation to provide an effective accommodation, but they do not necessarily have an obligation to provide the employee's preferred accommodation. So if the accommodation that the employee requested, if it's particularly expensive and or if it's, would be particularly difficult to provide, and the employer has an idea for an alternative accommodation that would be effective for, the purpose that the requested accommodation is trying to accomplish, then the employer can suggest that as an alternative and can choose to provide that as an alternative. And again, the key there is that it must be effective. So if the employer suggests an alternative that would be completely ineffective, it wouldn't work, it wouldn't actually help accomplish what the person is hoping to accomplish, then that would not, then an employer can't provide that as an alternative. Instead, they have to provide an effective alternative. And so we also want to talk about circumstances where an employer might not have to provide a certain accommodation or potentially any accommodation at all, depending on what alternatives there are and what would be effective. And so the general rule is that employers do not need to provide a reasonable accommodation that poses an undue hardship. And so when determining whether a particular accommodation would be an undue hardship to provide, there are different factors that are considered, which include the nature and cost of the accommodation needed, the overall financial resources, size, number of employees, and type and location of facilities of the employer. And so, this factor is important because a very small business might have a difficulty providing an accommodation that costs, several $100s or $1,000, but a very large business that has a lot of financial resources and a lot of employees might have a much easier time, and it might not be an undue hardship for them to provide that accommodation. you would also consider the type and operation of the employer and the impact of the accommodation on the operation of the facility. So if the accommodation might interfere with, with other work at the facility, then that might be an undue hardship. But if it doesn't interfere, if it doesn't cause any problems, in that case, that would weigh against it being an undue hardship. And so those are just some of the factors that would be considered when determining whether something's an undue hardship. So after the parties have discussed all of this and considered all of these different factors, the next step is selecting and implementing the accommodation. As we mentioned before, the employer ultimately chooses what accommodation they're going to offer. They do have to offer an effective alternative if they're not offering the preferred accommodation, but they do ultimately choose what they're going to offer. And after that, the employer and the employee work together to implement the accommodation and evaluate its effectiveness. It's important to note that the duty to accommodate is ongoing. It does not end as soon as the first accommodation is provided, because there might be changes to how the job works or to some, how somebody's disability is impacting their work. And so over time, there might be a need to change or adjust the accommodations that somebody's receiving. And that is absolutely something that the ADA obligates employers to do. The employer has to be open to talking if the employee needs to change or alter their accommodations, and to figuring out how to change those accommodations as necessary over time. I'm going to turn it back over to Megan.
Great. So we wanted to share with you this afternoon some really helpful resources that are available to both job seekers as well as current employees with disabilities. And the first of which is vocational services provided through the Division of Rehabilitation Services, or DRS. And some folks listening to this webinar today may have heard of DRS referred to as DORS or DORS. So we're talking about the same organization here. So just wanted to make sure there's no confusion. But the DRS administers a home services program that some of you may be familiar with for people with disabilities to help with activities of daily living. But they also administer a vocational rehabilitation program. And so we're talking about the vocational program when we're talking about tools for applicants and employees with disabilities. So the goal of the DRS vocational program is to help people with disabilities prepare for, secure, maintain, and advance in employment. Next slide, please. And so who is eligible to access these great services that are provided through DRS? So in general, to qualify for DRS vocational services, an individual must first primarily want to work. It's important that employment is a desired goal, as well as the individual must have a physical or mental disability that causes a substantial impairment. And specifically, that impairment must make it difficult for someone to work. And so once we've gone through kind of that three-pronged eligibility process, the applicant also must be determined to be able to, quote, benefit from DRS vocational services. And individuals who receive SSI or SSDI benefits are presumed eligible, but they still go through the application process of determining whether they would benefit from vocational services and what specific services are needed. Next slide, please. So to apply for services through DRS, there's kind of two main ways to do so. In the slides and the materials that you should have received, there is a hyperlink to a DHS office locator. So you can go to that website and put in the county that you live in, as well as your zip code, and find the local DRS office that is closest to you. In some of the smaller counties, there may be just one DRS office that works with individuals with disabilities. But here in the Chicago area and Cook County, there are multiple different DRS offices. So you can reach out to your local DRS office that way. And I should let you know that most DRS offices are still closed to in-person customers, and their staff are working remotely at this time. So you would have to call the local DRS office, and then someone would call you back. You wouldn't be able to go in and meet with someone that day or speak with someone in person that day, usually. You can also complete an online application form or a referral form. And again, in the materials, there's a link to that online referral form. And anyone is able to fill out that referral form. It could be the person who's directly applying for DRS services. It could be a guardian, a family member. It could be an advocate or a friend. Anyone is able to complete that online referral form on behalf of the individual. And regardless of if you reach out to your local DRS office by phone or send that online referral form, the DRS office is supposed to contact you within 30 days to reach out to you and start that application eligibility process about discussing your employment goals. Next slide, please. So once you've been determined eligible to receive DRS vocational services, the next step is for the individual to work directly with their assigned DRS counselor and create what's called an IPE, an individualized plan for employment. And that IPE document is really important because it outlines the individual's specific employment goals, as well as the services that DRS will need to provide to help the individual achieve and meet those employment goals. So it's really unique and tailored to the individual about what they're interested in and how they're going to go about achieving those goals to help them reach their employment objectives. And so what's important to note is that you can contact DRS and not have any idea about what your specific employment goal is, what you might be interested in or good at. That's totally okay. In fact, the DRS counselors are really experts at working with individuals, and they can request assessments and evaluations to really determine what would be a good path based on an individual's skills, interests, and strengths. And an important component of working with DRS and developing this IPE is a principle that's called informed choice. So this is something that is really important to your rights as a DRS customer. You are directing and want to have an important role in say in what your employment goal is and what you think you need to be successful in achieving your employment outcome. So the IPE document is supposed to reflect that collaboration. You and your counselor have talked together, really thought things through, and the final document that is the IPE represents kind of what you both have agreed to. In fact, the IPE must be signed by both the DRS customer and the counselor in order to be valid. And the IPE is reviewed at least annually. So you can, see how things are going and if any changes need to be made, but it can also be amended more frequently if someone's employment goals change in the meantime. Next slide, please. So we wanted to share with you some examples of services that might be available to an individual and might be encompassed in that IPE. So again, these are not the only types of services that are available, but are some things that could be available and helpful to either job seekers or current employees. So your IPE could include job training and job coaching. It could include help finding a job, job placement services. DRS could help pay for supplies needed for employment. It could be paying for a job uniform or things that you need to be successful on the job. DRS can pay for college or training programs. They can provide assistive technology or pay for vocational evaluations. DRS can also help with independent living supports, so things like housing and transportation. And there's a really great provision in the regulations for the VR program that allows DRS to provide, quote, all other goods and services that are necessary for the individual to achieve an employment outcome. So this is great for us as advocates because we can really advocate for an individual to work with their counselor and ask for things that they can tie to that specific employment goal that are necessary. Next slide, please. So I'm going to turn it over to Sarah to talk a little bit about the client assistance program and the services we can provide.
So as Megan and I mentioned at the beginning, both of us are now a part of Equip for Equality's new client assistance program, or CAP team. And what CAP was established by the Rehabilitation Act, and a large part of what we do is that we help people who are apply for or receive services under the Rehabilitation Act, which includes people who receive those vocational rehabilitation services that we were just talking about, and independent living services. And so, you know, that when somebody is receiving those, when somebody contacts DRS to receive VR services, and if they have an issue with those services, CAP is there to help, essentially. And then we can also advise people of their rights and inform people about their rights under Title I of the Americans with Disabilities Act. So, you know, provide the sort of information about reasonable accommodations or, discrimination, those sorts of things that we've been talking about throughout this presentation. Across the country, most CAPs are housed outside of the state government, so outside of the agency that provides those vocational rehabilitation services. Many are within the State Protection and Advocacy Organization. But until recently, the Illinois CAP was actually part of DRS. So it was internal at DRS. And that was the case until July 1st of 2022, when the CAP was redesignated from within DRS to Equip for Equality. And so that is why CAP is now part of Equip for Equality, and why Megan and I are now part of the CAP team. And so we wanted to also provide a few examples of the sort of assistance that we can provide to DRS applicants and customers. So, if you reach out to DRS and you're looking to obtain services and you're encountering some sort of issue, these are sorts of things that you can reach out to CAP for help with. It can include if somebody's just looking for services and they just don't know where to start, they don't know how to get in touch with DRS, they can reach out to us and we can help point them in the right direction. If they can't figure out how to open a referral, we can help with that. And a referral is, like, as we mentioned earlier, essentially that original application for services. Maybe they've created a referral, but no one's followed up, no one's gotten in touch with them. We can help reach out to DRS, figure out what's going on and get them connected to the appropriate people. We can also help if somebody's been found ineligible for DRS services and they want to challenge that decision. Or if somebody has created an IPE, but maybe they disagree with the goal that the counselor ultimately put in the IPE, or they think it should be changed, that's something they can reach out to us for help with. We can also just help with general disagreements about services about what services are needed. If somebody's been denied a specific service, we might be able to help appeal that denial or work something out with the counselor to get things figured out. We also help if there's just miscommunications. Maybe someone's having a hard time figuring out how to talk with their counselor and how to get their counselor to understand what they need. We might be able to help with that. And we can also help if DRS closes a person's file and they want to see about getting it reopened or figure out why it was closed. And so those are just a few examples. There are other things we can help with as well, but that kind of gives you an idea of the scope of what we can do to help people who are receiving these services. And then, as we mentioned earlier, we can also provide some assistance with Title I of the ADA issues. And so this is things like answering questions about disability disclosure, reasonable accommodations, challenging discrimination. We might be able to do some limited advocacy, helping people write requests for accommodations or helping brainstorm solutions for when dealing with challenging employers. Sometimes we'll work collaboratively with counselors and DRS customers to try to figure out how they can get an employer to be more agreeable to a certain accommodation. And so those are some ways that we can help people who receive VR services or are eligible for VR services with employment issues. So we wanted to highlight the contact information for CAP. The phone number is 855-452-2725. We have an email address, cap@equipforequality.org, that you can reach out to us at. And we also have a website, equipforequality.org/CAP, that you can find more information about CAP. And also, I believe that website will have a recording of this webinar if you ever want to revisit it. And you can also reach out to us directly. Our CAP director and managing attorney is Rachel Weisberg, and her email's there. And then I'm Sarah Huttenlocher, and my email is listed as well as Megan's. And then there's another member of our CAP team, Emily Wilson, who focuses a lot on transition issues. So students who are transitioning from high school into the workforce or into college and are looking to receive vocational rehabilitation services related to that transition. Emily is a good person to contact about those sorts of issues. And so now that we talked about CAP and VR services, we want to talk about a few other resources that might be helpful. And one of those is Equip for Equality's Employment Rights Helpline. And so the helpline provides advice on employment rights of job seekers and employees with disabilities to all people with disabilities in Illinois. So the ADA advice that the Employment Rights Helpline can provide is not limited to just recipients of VR services. Equip for Equality's Employment Rights Helpline can assist anyone who has a disability in Illinois and is looking for that sort of advice or information. And some things that the helpline staff can do is discuss your rights under the ADA and provide more information on them, answer your questions about your rights, assist with reasonable accommodation requests, help you understand your options if maybe you're dealing with a difficult situation at work or a difficult situation with a job application and you want advice on like what options you might have. We can share fact sheets, sample letters, and forms. We can also provide referrals, and in some cases we can provide additional assistance, potentially helping people if they figure out how to like file a charge against their employer or help people in negotiations. So we can provide additional assistance in some cases as needed. And the helpline's information is at the bottom of that slide there. So one other resource we wanted to highlight is the Job Accommodation Network, or JAN. And this is a really good resource for job seekers with disabilities, because if you're struggling to figure out, if you think you might need an accommodation for a job, but you're struggling to figure out what options are available and what you might need, and you don't really know like what's going to be considered reasonable, JAN is a really great resource. They have fact sheets and accommodation ideas for almost every type of impairment or disability. And they have a great like searchable database on their website that you can search alphabetically. You can also search by like type of disability or type of like accommodation need and find all kinds of really helpful ideas. They also have technical assistance available if you want to talk with somebody at JAN and get some thoughts on like what might work best for your situation. They also have guides for employers that can be helpful for employers who are hoping to learn more about what reasonable accommodations are and when they might need to provide them. And they also have sample reasonable accommodation request forms, sample reasonable accommodation forms for employers that employers can use and provide to employees as a way to fill out and make accommodation requests. So it's a really helpful resource. And if you're looking for ideas on accommodations, JAN is a great place to start. I'm going to turn it back over to Megan to talk about 2 other EFE programs.
Great. So just in closing, we wanted to share some programs that are on the newer side here at Equip for Equality that may be beneficial to folks who are listening today, or you may be able to identify them as resources to other folks within your networks. The first program that we wanted to talk about is funded by the Access to Justice program. And so Equip for Equality, through many of our class action lawsuits, we work with individuals with disabilities who are incarcerated in the Illinois Department of Corrections. But through this specific grant program, we're working with people with disabilities who are leaving those jails or prisons and transitioning and re-entering society. And for many people with disabilities, even people without disabilities, there can be a real challenge of accessing healthcare and employment and other programs and services when leaving those jails and prisons. So this grant program is set up to help folks to address those civil legal issues that they're facing when they're leaving the jails and prisons. And we also are assisting folks while they are incarcerated in understanding how to petition for release or conditional release and prepare for that reentry process. So, and with so much of the work that Equip for Equality does, in addition to doing those individual cases, we're constantly exploring systemic barriers, particularly with this grant program, the systemic issues that really make it challenging for people with disabilities to re-enter after they've left the jails or prisons. So our colleague Ruben Batista is the contact person. So you can reach out to him. His email address is in the slides. And the second program that we wanted to share is funded by the Illinois Equal Justice Foundation. And as some of you may know, there are new laws in Illinois that have legalized cannabis. And so for that reason, expungement of cannabis criminal records may be an option for folks now. So the Illinois Equal Justice Foundation provides free trainings and seminars about these new laws and the potential for expungement. And some of these criminal records can really be a barrier to folks who are looking for jobs as well. So if you are interested in accessing these trainings and seminars, the contact person is our colleague, Barry Taylor, and his email address is included in your slide materials as well. So before, I think we've saved a few minutes for questions because we started a bit after noon, but Sarah and I are just really thankful and appreciative of your attendance. And we hope that this was a beneficial session, that you learned more about Title I of the ADA and some of Equip for Equality's programs and services. So thank you so much.
Thank you, Megan and Sarah. That was great. So someone did ask in the chat or in the Q&A if we can send out the PowerPoint after this. We definitely can. And then we have Catherine raising their hand. I'm going to allow them to talk and ask their question.
Hi, can you hear me?
Yes.
Okay, so my question is, when you talked about accommodations and somebody calling on a person's behalf, what is supposed to happen in that? In my situation, what has happened to me in the past, which I didn't find out until after the fact, is that I have a family member calling, quote unquote, on my behalf and giving misinformation, and I believe this has kept me from employment. And I recently did get a job, and I had to tell my employer that my mother might call and want to speak on my behalf, and it was just so embarrassing to, I finally got a job after years not being able to get a job, and now I have to bring up this family issue, and I'm wondering what your advice to me would be in that. And then also, this is a different question but kind of related. I currently live with these people that have been sabotaging my employment for the last 10 years. And I'm wondering if under the vocational services, if I could get housing so I don't live with people who sabotage my employment so that I can maintain my employment, or is that outside of the scope of what it's about?
Sarah, do you want to tackle that first, and then I can feel free and chime in? First of all, thank you, Catherine, for your question, or questions, I should say.
Yeah, so yeah, kind of two different questions. I think that the first one is complicated to answer because the employer obviously doesn't really have control over whether a family member is reaching out on your behalf about these things and giving misleading information. So I'm not sure if it's I don't know if that's really an employment rights issue. I mean, they shouldn't respond to that information by, then ignoring if people are responding to that misleading information by refusing to hire you, then that could, and they're doing that solely because they believe you have a disability, then that, it could be discrimination. But I don't know if there's anything that the ADA can do about the fact that you have this family member who is doing that. So much as, employers should not be responding to that in a way where they are then reacting by not talking with you at all, ignoring, and just choosing not to hire you rather than talking with you about accommodation options or asking you even if this is true. And so, the employers should be responding to that in a more appropriate way, but I don't know if the law can do anything about somebody reaching out on your behalf. And then to your question about housing, and there are some circumstances under which DRS can provide housing support or housing assistance to help people obtain employment. It would depend on the very specific circumstances, and so you would have to reach out and initiate that process and talk with DRS about it. But it's certainly not something that's outside of the realm of possibility if that's something that's necessary in order for you to maintain employment.
Thank you. Can I?
Sorry. I just
Oh,
need to jump in. Our interpreters have to leave. The captioning, I think will still be available, although I'm not sure. I am sorry about that. We are recording this, so potentially could get like a transcript of the end of this to someone who might need it. Just wanted to say that. And I also have some thoughts on the employment situation after Sarah and Megan are done.
Great, thank you, Hannah. Catherine, I did want to share, and there's by no means that you have to disclose any of this in this webinar setting, but I would encourage you to reach out to us. You can contact our main phone number, as well as if perhaps you have a guardian who is not expressing, not honoring your wishes or things like that. That's something that Equip for Equality generally can assist you with. So that might be something that we could help. But I would encourage you to reach out to, you could reach out to our CAP line to talk about the employment issues after Hannah shares more thoughts, so that we can perhaps delve more into the facts of your specific case to see if there's any recourse or advice that we could provide to you.
Thank you.
So Catherine, regarding your employment situation, or like future employment situations like this, again, I agree with Sarah that the ADA doesn't cover kind of rogue family members, but I will say in my experience with employers in these situations, typically they don't like to communicate with family members. Even if someone is a guardian, it tends to be, you kind of have to, most employers in my experience will like make you prove that person's guardian. And if they're not, they probably won't speak to that family member. I know that it's inconvenient, but I think probably the best way to get ahead of it moving forward is just letting them know, hey, I have a family member who crosses lines. Sometimes they may reach out to you to talk about me. I would appreciate it if you just wouldn't respond to those things. I think that's kind of the best way for you to get ahead of it and handle it. That way they hopefully won't even, if they receive a voicemail or an email, they just will delete it and not respond. It's unfortunate, but I would say just in general, employers don't really like to talk to family members that much. I mean, if you're medically incapacitated, you're in the hospital, you can't provide doctor's information. And in those cases, like definitely your family member can be the one to send it to the employer, and the employer should accept that. But I don't think it seems unlikely to me that an employer would be very willing to talk to your mom.
All right, thank you.
Yeah, you're welcome. Do we have any other questions or comments, thoughts, anything like that? Again, you can, like Catherine, you can raise your hand or you can put it in the chat or the Q&A. Okay, it looks like no. So thank you so much, everyone, for being here. We really appreciate your time, and thank you, Sarah and Megan, for your presentation. I hope everyone has a wonderful day. Goodbye.
Bye, thank you.